Kings of England had previously used widows and orphans and those who were not of age to take their inheritances. They'd used them, as it were, as bargaining chips. You could marry off these rich widows to your favoured courtiers. You could really make your own men into substantial barons by marrying them to a great heiress. Now, there had always been disquiet about that. The whole question of the rights of widows is present in the Coronation Charter of Henry I that was issued 100 years before Magna Carta in 1100. And there, the right of a widow to control her own fate looms quite large. The intention in 1215, though, was really to prevent the king using these rich women to promote his own despised, alien outsiders to positions of power in England. And it thereafter becomes a standard part of English law that widows have certain rights, and that provided they don't marry somebody who is obnoxious to the king, they have free disposal of their own estate. I think it's more a reaction against the rise of the new men, particularly the aliens, the foreigners, the Frenchmen at John's court. Bear in mind here that one of the really big things about John's reign is that he lost control of his lands in France, and that those defeats in France were absolutely central to the popular perception of John. Now, in 1204 he lost Normandy, he lost Anjou, he lost all the estates that had been held with the English crown since the conquest of 1066. In order to recoup those losses, he built up not only a vast war chest to pay for reconquest overseas, which really cost him political relations with the barons because he had to tax very hard in order to raise that money. But he also drafted in large numbers of leading figures from Normandy and above all from Anjou and Poitou, promoted them at court, and the best way of promoting them was to marry them off to rich widows. Clauses 10 and 11 superficially seem to be about an anti-Semitic attack on the Jews. They're not really. They're about kings as protectors of widows and orphans. They're about the institution of Christian law within society. Christian law says the ruler must protect the weak, and widows and orphans, well, people don't get much weaker than that. Christian law also, derived from the Bible, says that usury, the charging of interest, is a sin. It's a bad thing. Now, there was a need for credit in the Middle Ages, and people got around that, as they do today, by all sorts of means. The Jews were established as a privileged group that could lend money to Christians at interest without breaking the rules of religion. And the problem there was that because the Jews were under the king's protection, and because when a Jew died, the king took over his money-lending operation, the king began collecting Jewish debt in a very harsh way. He began seizing the estates of those who couldn't pay the Jews. As today, the people who borrow money from those who can lend money are generally those least able to repay it, and as a result became involved in the land market and in the market in Jewish debt in a way that was regarded as entirely unacceptable. Now, what's interesting also about that clause 10 and 11 is that it's in the 1215 Magna Carta, but it drops out thereafter. One assumes, because the whole question of the king's exploitation of the Jews was such a hot political potato, and because that economic exploitation was so important to kings, that it couldn't actually be accepted into English law thereafter. So the regulation of Jewish debt, which goes on throughout the 13th century, was really controlled within a context that wasn't any longer determined by Magna Carta. Clause 12 concerns a tax called scutage, and it derives from the word for a shield, a scutum. It's shield money. It's the money that knights paid when they couldn't actually go or didn't want to go and join the king himself in person and fight in person. They paid tax to the crown. Now, it had been exploited at an increasing rate throughout the 12th century by Henry II and King Richard I. And they'd begun to increase the rate at which scutage was charged, and they'd also begun to demand it for more and more campaigns. They were militarily successful, and therefore they fought a lot more, there were a lot more wars, there were a lot more scutages to be paid. It was a tax that particularly affected the knightly classes, not so much the barons. The barons actually got a profit from scutage because they collected the scutage from their knights. But the knights suffered. And the problem in John's reign was also that the king began to fight campaigns in what the knights began to regard as foreign lands. France, even Normandy, certainly Poitou and the southern parts of France, were no longer, as it were, closely bound into English history. And therefore these knights found themselves being asked to go either to campaign with the king in southern France or to pay a large sum of money to the king. This became a very unpopular tax. Clause 17 of Magna Carta tries to establish a firm basis for law to be administered. Now you've got to bear in mind here that law, as we take it, this great administrative structure with judges and barristers and so forth, was very much in an embryonic state in the early 13th century. Law followed the king on the whole. The king was the supreme judge. And the king exploited law for his own financial gain. Law wasn't so much about justice, it was about the king imposing the law and making a profit in the course of that imposition. What Clause 17 attempts to establish is that there should be somewhere, and in this instance we're talking about the bench, the band of judges meeting in Westminster Hall, there should be somewhere where people could go and know that they would receive a fairly speedy settlement to their legal claims. Now, in later history, of course, this develops a whole mythology of its own, so that in the 17th century, when common lawyers began to get very, very worked up again about Magna Carta, that clause was taken in a very literal sense to mean that the bench of justices in Westminster Hall should not even be moved the distance of 3 inches without infringing the basic constitutional rights of Englishmen. Now that's to misinterpret the nature of this clause in a rather dramatic but nonetheless rather entertaining way. So Clause 33 about fish weirs is generally taken as the joke clause of Magna Carta. What on earth have fish weirs on the River Thames and the River Medway, what have they got to do with the broader story of English politics? Now, there are actually 2 answers to that, and they're both really rather significant. The first is that this shows the degree to which Magna Carta was determined by the demands of the Londoners, the men of London, and to some extent perhaps also by the Archbishop of Canterbury, Stephen Langton, who had estates on the River Medway. But the Thames and the Medway were the rivers that fed London, and it was terribly important for the Londoners that the river navigation remain open, that their ships could pass freely up and down the river. Fish weirs were these great collections of palisades and stakes made in the river to trap fish, and they impeded the shipping. The second really even more important point about this clause is that it can be seen as the most extraordinary sort of petty localism, pedantry, minor disputes about fish. But really what it's talking about are the public possession of certain public things, what we would call res publica, the republic. And just as today we take it for granted that certain places are privileged, so roads have their own laws, the seacoast has its own laws, there are all sorts of laws even today governing the navigation of canals and rivers. All of those are in the public domain, and Clause 33 actually takes river navigation and says, no, this isn't a private thing, this isn't about lordship or exploitation or the making of money, this is something that has to be regulated for the public good. We're a very long way, of course, from fish weirs to the welfare state, but you can see the course of progression there that could be mapped out. From the king as this rapacious collector of other people's resources, to the king as the person who protects the public good, in this instance by obeying a charter that he himself has issued. If we're looking for constitutional principles in Magna Carta, which is what most historians always are looking for, then clauses 39 and 40 seem to be the only really significant constitutional clauses, that justice should not be sold, that justice must be done, and that judgment and justice should be determined by your peers, by your equals, what we would later on come to regard as the right to trial by jury. Now, historians find those constitutional principles there. The big question is, were they found there in the 13th century? And I think the answer is probably yes, they were. The best evidence for that is something called the Unknown Charter. Now, it's not really unknown. It's been known about since the 1860s. But this is a very early draft of Magna Carta. It's probably the first draft that we've got of Magna Carta. And at the very head of that Unknown Charter, we read, King John concedes that to no one will we sell or delay justice or right. Basically, it begins with Magna Carta clauses 39 and 40. So in the very first draft of this document, they were at the head. There's one other thing to say about those clauses. They're often said to be revolutionary. They're often said to be completely new, to really transform the relations between king and subjects. Now, that isn't true. The sale of justice had been forbidden long before this. Roman law, the law of the Roman Empire, is insistent that justice must be equitably done. It must not be sold. The church had insisted that the justice of the church courts should not be sold. There are a whole series of church councils in the 12th century that enacted legislation forbidding the sale of justice. So there's nothing particularly revolutionary about these clauses, save for the length at which that principle is articulated. And perhaps more importantly still, save for the fact that in due course, these privileges that are extended really towards the barons and the freemen, we are told later on, are to be extended by the barons and the freemen towards their own subjects, to become the common possession of the people of England, to become the common possession of the common people, the peasantry. Clause 47 is about the exploitation of forests. Now, this is rather more complicated than the business of fish weirs. The forests were really a very, very big bone of contention between king and barons. What Clause 47 does is kick into touch the whole question of how the king can exploit the forests. But if you think of the archetypal medieval hero, Robin Hood, well, the forest obviously looms very large in his life. What was so wrong about these forests? We're talking about an age of economic expansion where fuel, timber from the forests, is very necessary. We're talking about an age of subsistence agriculture where the only way really of producing enough agricultural produce is constantly to bring new land under cultivation to feed a growing population. All of those needs come up against the fact that from 1066, and probably from a long time before that, about a third of the land of England was declared to be forest. It didn't all belong to the king, it belonged to private landholders, but they could not cut down trees. They could not have hounds able to run around catching deer and wild boar and all those other things that live in the forest. They weren't allowed to shoot at the deer or the hares or all the other animals that lived in the wild. Above all, they couldn't clear the land of trees. That meant that if you were a big successful baron, wanting to exploit your own resources for your own needs, you couldn't do so without risking very, very hefty penalties to the crown. And the crown laid down draconian punishments, the lopping off of hands and feet, for those who broke the laws of the forest. So forest law was a really big bone of contention in the 13th century. It would be the equivalent today of the Queen saying that in your own home you cannot, what should we say, turn on the taps or switch on the electricity or build yourself a spare bedroom. You can't do any of that without paying a hefty fine to her. The forest also had implications not just for barons who want to exploit their own resources, but for peasants. Peasants keep hounds. They want to occasionally poach in the king's forest. They want to cut themselves some timber for their own fuel, for their own fire. And forest law imposes really ghastly punishments, mutilation on those peasants who break the laws of the forest. What's interesting, of course, is that the great forest charter that comes out of this clause, there's a whole charter of its own called the Forest Charter in 1217. It's because of the distinction between the Forest Charter and this Great Charter of Liberties of 1215 that we begin to call the Great Charter of Liberties the Great Charter, Magna Carta. But the Forest Charter actually privileges the barons rather than the peasant. It's very largely about the rights of barons to the exploitation of their own land, and the peasant can go hang. I suppose my favourite clause of Magna Carta is Clause 50, because Magna Carta is often seen as this extraordinary statement of right and liberty, and everyone's very pious about it, and they take it all very solemnly. But Clause 50 actually enshrines xenophobia and the hatred of foreigners in the middle of Magna Carta. It is, if you like, the UKIP clause of Magna Carta. Now, I say I like it, I don't actually like that particular programme that it advocates, but it's some indication of the significance of relations between the French and the English in 1215. That we're beginning to see the emergence of real tensions in English history between us, the English barons, who are all of French descent, and them, the French. And it names a bunch of people, Engelard de Sigogny, so-and-so de Martigny, Girard d'Athey and his relations, that nobody today has much heard of. But one of those names, the name Philip Mark, which appears in Clause 50, has rung down the ages, because Philip Mark, of course, was the Sheriff of Nottingham. And if you ask anybody, what does Magna Carta tell us about, it obviously, of course it doesn't, but it is generally thought to have something to do with Robin Hood. And here we have the Sheriff of Nottingham slap bang in the middle of Magna Carta being expelled from England as a foreigner.